Yes, judges can be impeached for activist decision-making. It's in the Constitution, and it was put there specifically for that purpose. First up is, I believe, an issue that is undermining the rule of law and our constitutional structure of government, our Republican form of government, which at the federal level is constructed through three departments, right? The executive branch, the legislative branch, and the judicial branch. And the powers are supposed to be distinct and not reside within one branch, because if one branch has all the powers, the executive, legislative, and judicial powers, that becomes a dictatorship, obviously, to the founders' intent of distributing the powers across the branches in a way that allowed for checks and balances, and all of that means, and the result of that is that our liberties are better protected, because it's harder for any one branch on its own to gain too much power at the expense of our individual liberties. But we're facing a challenge in that regard as a result of anti-Trump animus within the federal judiciary. Now, of course, given Trump's historic and unprecedented and much needed reform efforts, he was going to face pushback in the courts from the organized left. The public employees unions, the Soros operations, the Soros-funded NGOs, taxpayer-funded NGOs demanding more taxpayer money that they say they have a right to, so that we pay them money to sue the government to get more money. That's the way things work in our modern system. And that's fine. You know, people have the right to bring claims to court, and that's why we have a legal system. The problem emerges when the courts start playing politics with these claims and start making up laws as they go along and asserting authorities they don't have. Just in the last week, we had at least two judges assert authority in my view, they don't have, which is to require the President of the United States or his agencies to hire people back by the thousands that they've let go because they were probationary or for other reasons. Now, the last I checked, the President has the right to hire and fire individuals. Obviously, there are constraints. But the notion that employees, in an emergency fashion after they lose their jobs, can go to a federal court and get a federal court to immediately order them to be hired back, that's not the way our system is supposed to work. So I'm not a lawyer, so I'm not going to go through the bases for getting an injunction, an emergency type injunction, or a temporary restraining order. But I can tell you, I think in a summary way, that the relief that's being sought by individuals seeking to get hired back is not available to them under these emergency court actions. There's no emergency. They can wait a few months. They can get their jobs back then, if at all, or they can get compensated. There's no life or death emergency that requires the court to come in and usurp a president's executive powers. Now, I know there have been questions as a result of those types of decisions, and frankly, the Supreme Court, and there have been a few courts that have pared back some of the abusive lower courts, but not enough. And the Supreme Court hasn't done enough in this regard as well, as you may recall with that, in my view, terrible decision by the three liberals plus Justice Amy Coney Barrett and Chief Justice Roberts to essentially allow a lower court to force the President of the United States to spend money on foreigners abroad, despite his best good faith concerns about doing so and wanting to pause it. And he ordered the immediate expenditure over disputed funds. Again, completely outside the judicial norms. And so when the judges act like that, and in a way that isn't explained by law and order, and is explained by politics, that's an abuse of power that the framers were worried about. And the response by many to that is, well, can they be impeached for activist judicial decision-making in a way that undermines the rule of law? And the answer to that is yes. And I wrote an op-ed for Judicial Watch for the Washington Examiner. And the headline, and it's worth going over, because just because they can be impeached doesn't mean they will be impeached, or it's really, practically speaking, politically possible to impeach them. But it's worth highlighting that impeachment is a tool given to us by the framers, not because a judge is corrupt. I mean, that would be covered by impeachment, but because a judge exercises powers not available to him in the Constitution in an abusive way. And the headline of the, I think the Examiner came up with this one. I don't remember if I did this headline. The constitutional option, impeachment of activist judges. And I highlight, these issues that I was just talking about. And, as we detail in the op-ed, when judges start to act as president, that's something that the Constitution frowns upon. Because as we say, Article 2, Section 1, Article 2 is the section of the Constitution that largely explains the president's powers, the enumerated powers. Article 2, Section 1, Clause 1 of the Constitution unambiguously states, the executive power shall be vested in a President of the United States of America. Not in judges, not in Congress, but a president, one man. Powerful position when you think about it in that regard. And this is in explaining what is now known as the vesting clause, the powers vested in him. White House Deputy Chief of Staff Stephen Miller said, a president is elected by the whole American people. He's the only official in the entire government elected by the entire nation. And the threat to democracy, as Stephen goes on to say, and he understands it's a constitutional republic, but it's a constitutional republic with democratic aspects, including the election of the President of the United States. The President is appointed, so the executive power is given to someone democratically elected within the constitutional rules set forth, the Electoral College, the individual state elections, etc. The threat to democracy is the unelected bureaucracy of lifetime tenured civil servants who believe they answer to no one, who believe they can do whatever they want without consequence, and believe they can set their own agenda no matter what Americans vote for. And obviously that's true for many in the deep state, too many bureaucrats, but it's also true for too many judges. There's a great book by Judge Bork, the late Judge Bork, wrongly, in my view, denied a seat on the Supreme Court by the radical left. And I think, what was the name of the book? Was it The Tempting of America? Because I read it now probably 30 years ago. Anyway, you can look it up. And he said the great temptation for judges, no matter their philosophical stripe, is to kind of talk yourself into imposing your political or your policy preferences through your judicial decision-making. And his view was that his philosophy of judicial decision-making was the best guard for that happening, originalism or, a traditional original intent or original intent type approach to judicial decision-making. You try to figure out who wrote what the Constitution said, what it meant when it was written, what those, to the degree it's unclear, what those who wrote it intended, and try to apply it to the current day, as opposed to, I want abortion on demand, so I'm going to just make up constitutional principles that let me get to that result. It's a great temptation. And not only did Judge Bork say you got to resist that temptation, but the founders had a check in place that if you didn't, there was a way to police you. And it was the impeachment power. And I'm not just interpreting this. The founders said it because other Americans were concerned that the Constitution would allow the judicial branch to take over. And they said, don't worry, don't worry, you can sign on to this Constitution, you can ratify this Constitution, because we have these checks in place. And one of the checks, the ultimate check, was impeachment. And let me read you the section of the op-ed that talks about that. Now, of course, I don't have the full. Okay, I'm missing part of the op-ed, unfortunately. Oh, I see what happened here. In persuading the people to ratify the Constitution, Alexander Hamilton explained in Federalist Papers number 81, you can go look it up, number 81 of the Federalist Papers, that while the judiciary may occasionally encroach upon legislative authority, this applies to executive authority as well, its comparative weakness and total incapacity to support its usurpations by force limits the danger. So that's one way, the judges basically rely on people listening to them because, the president has the military and, Congress can ignore them as well. So they don't really have the threat of force behind them. They have to have legitimacy in the eyes of the other branches. He added that this is greatly fortified, this is a quote, greatly fortified by the consideration of the important constitutional check, which the power of instituting impeachments in one part of the legislative body and of determining upon them in the other would give to that body upon the members of the judicial department. This alone is a complete security. So they found or understood and put the impeachment power by Congress for judges at the federal level. They put it there as a complete security for our liberty against usurpations by the judicial department of powers not entrusted to them by the Constitution, executive and legislative powers. Now, the interesting thing is it was essentially just tried once. And as I note in the op-ed, the use of the impeachment power to restrain judicial department usurpations has essentially lain dormant since 1804, when Supreme Court Justice Samuel Chase was impeached by the House for, among other alleged misconduct, tending to prostitute the high judicial character with which he was invested to the low purpose of an electioneering partisan. So he was doing what Americans are generally concerned about, engaged in partisan behavior under the guise of judicial decision-making. That was the allegation. So he was impeached by the House, and there was a lot of politics about that. He was the framers were at each other's throats, and the founders were at each other's throats for a variety of reasons there, and he was on the wrong side of one of those battles. But he was impeached. And ultimately, however, Chase was acquitted by the Senate, so he wasn't removed. Now, since then, there have been judicial impeachments, but not because of judicial activism. It's always been, as best I can tell by the history, the impeachments of federal judicial officers have been for misconduct, bribery, that type of thing. Lying, obstruction of justice. Famously, Judge Alcee Hastings was impeached and removed. Where he ended up after he was impeached and removed from the federal bench? He was a congressman. He's a congressman for many years. We ended up suing him for a client. He's terribly corrupt. He was a corrupt judge, and then he turned into a corrupt congressman. But the point is, there's been no impeachment for activist judicial decision-making, abusive activist judicial decision-making since 1804. Does it mean it can't be done? No. But it shows you the difficulty of even getting the approval of impeachment of any of these judges out of even the House because of the historical precedent. And obviously, it's always going to be a challenge in the Senate. Now, just because there won't be a trial or a trial will be short-circuited or likely to fail in the Senate because of the partisan makeup, it's not my view that that impeachment should not proceed in the House, because the House has separate independent obligations. If there's an impeachable offense and the majority of the House agrees, then they should vote on it. And then it's up to the Senate to handle it appropriately. So there have been several articles of impeachment, or several judges who have been targeted with articles of impeachment. So that dormancy that I talked about may not last much longer. The House may begin impeachment proceedings, or in the least, this is what I would recommend, that they have hearings on the impeachment of federal judges. Talk about what the process is. Further explain the history that only I was able to get into briefly in an opinion editorial. But, to be clear, we have a right to protect our constitutional republic from lawless judges. And the Constitution gives us a tool to do so. And there are various tools. And one of those tools is the impeachment power. Should it be taken off the shelf and used? I defer to you, dear voter, dear citizen. But I do think it should not be ignored. And we can look at individual judges and see if they've engaged in behavior that would rise to impeachable behavior in terms of activism and just playing politics on the bench. And then, of course, if you're going to do that, you have to recognize that others that you may take a more liberal view, right, of what constitutes impeachable behavior, which is a decision they don't like at all, even if it's lawful and non-political. So, maybe that's one of the reasons that, it hasn't really proceeded much, because it would make judicial decision-making potentially more hazardous in terms of leading to all sorts of impeachment proceedings. But yes, judges can be impeached for activist decision-making. It's in the Constitution, and it was put there specifically for that purpose. So I encourage you to read the op-ed. I put it below. There'll be a link to it below. And, the left is out of control, and my concern is these courts are kind of echoing the craziness in some of their vituperative comments and their decisions concerning Trump. You read some of this stuff and it's like, how is this judicial? It's one thing for me to go on a weekly update and start yelling about stuff and saying things that, maybe the next morning it's like, I shouldn't have said that, right? But judges are always supposed to be judicial, and that means having even keel temperament. So I think there are a lot of temperament issues at issue here, so there may be some ethical issues. I think they've made political statements and criticisms of the president that were unneeded, and just engage. It's basic politics, and there's got to be a pushback some way against that. Either just regular criticism, which is appropriate, or congressional investigation and impeachment. And we kind of see it's probably not the best case, because I confess that the law here, I'm not a lawyer, but I call myself an expert layman in the law, right? I know a little bit more than the average person about legal matters. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.